Mr. Alagishin,
Good afternoon.
are you ready to proceed?
We are, Judge.
All right. You have pretrial motions. You are seeking a hearing. Tell me what pretrial motion you're going to start with.
If the court wants to do the non-evidentiary ones first, we can get through those. And those are pretty quick and easy, I would think, Your Honor.
All right. Tell me which motion you're going to go with.
Yes, Your Honor. At this time, I would ask the court to review the request to have a court record all proceedings, whether it be pretrial or trial. And we're just asking that be granted.
That all proceedings be recorded.
Yes, sir.
That order shall be granted.
The next one we have, Your Honor, is a request to have the state produce a witness list prior to trial. The normal requirement to the rules, they provide at least 10 days before, and we're just asking that be granted.
I'm sorry. You're being a little too quick for me.
I'm sorry, Judge. The next request was to have the state produce a witness list at least 10 days before trial.
Witness list. 10 days before trial.
Yes, sir.
That is granted.
We also filed a request for exculpatory and mitigating evidence, Judge. We're just asking that that be granted at this time as well.
That's basically a Brady motion.
Yes, sir.
That's granted.
We're also asking for a 404B motion, Judge, on being provided extraneous evidence and notice thereof.
Since we're being technical, there is no motion, but there is a request for notice. The court
Yes,
takes
sir.
notice, and that is granted.
We have a discovery motion that we put on file, Judge. We did receive electronic discovery, but out of the abundance of caution, we wanted to make sure that none of the items in my motion have been missed. And so I don't know if it's easier for me to visit with the state if they have any opposition, or if they're fine with it, and the court can grant a request on the various items listed in that motion.
Ms. Morgan, and you're muted right now.
Your Honor, no opposition to what he has requested. We have already requested that from Converse PD, and it has been confirmed that it should be downloaded in the next 48 hours.
No opposition from state. The discovery, you want to identify it so there's no question of what it is, Mr. Vail?
Yes, Judge. In terms of the discovery request, we made 12 specific requests, Judge. It's up to the court, but I would just represent the items requested in paragraph 1A through L, which relates to providing information concerning witnesses, pictures, videos relating to the location of the arrest, anything relating to my client in terms of any images made of him, any statements, any diagrams, any reports, any agreements with witnesses that may testify in this case, and any issues of psychiatric, mental issues, or other problems with witnesses that may testify in this case. And again, they're listed in paragraph 1, items A through L. And it's also listed that way in the proposed order to the court.
The state has announced no opposition, so those motions that have been filed are granted, and they are specifically identified in the record.
The next set of motions we have, Judge, are evidentiary motions. The first is a motion to suppress evidence. And on that, we would require testimony from Officer Cooper.
Motion to suppress Officer Cooper.
I
It's your
believe it's
motion. It's your motion, Mr. Vail.
It is my motion, Judge.
Pardon
It
me?
is.
It is your motion to suppress.
It is my motion, Judge.
All right, Ms. Morgan.
Yes, Your Honor, the state is of the position that a motion to suppress on an evading arrest case is improper at this time. And I have some case law to go with it. It's asking the trial judge to ask the state to prove an element of the offense. And it goes to the merits of the case, which is better for a directed verdict at trial rather than for a motion to suppress. And that comes from Woods v. State, which is a CCA opinion, and Day v. State, which is also a CCA opinion.
What's the second one?
Day v. State.
Spell it D-A-Y?
Yes, sir.
Okay, what are the sites specific?
Yes,
Woods
for
is what?
Woods v. State, it is 153 SW3D 413.
And on day?
The day is 614 SW3D 121.
All right, let me read these back to you. Woods v. State, cited as 153 Southwest 3rd, 413, and Davie State, 614 Southwest 3rd, 121.
That's correct, Your Honor.
And you are asserting that these say specifically the motion to suppress by the defense. Mr. Vale, tell me what your motion specifically says.
The motion specifically says that we're asking the court to find that there was no reasonable suspicion to stop or detain Mr. Olegishin. We are also further asserting that if reasonable suspicion could be established, that the officer didn't have a right to arrest Mr. Olegishin at the time. Our concern specifically relates to the circumstances surrounding the contact and subsequent basis for the arrest. According to the officer's report, Your Honor, he had foreknowledge of alleged warrants for my client, which gave him, according to his report, the basis to arrest him. However, we don't believe that that is in fact an accurate rendition of the circumstances that evening. And we believe that he did not have reasonable suspicion to detain Mr. Olegishin and subsequently didn't have knowledge to arrest him until after the fact. And so we do believe that the motion to suppress and the motion to dismiss the case are both timely motions. I've not been presented with a copy of either opinion, but I'm happy to review them and provide a response to them. Every motion to suppress, Your Honor, goes to a merits of a case because it goes to whether or not there was a reason to have interaction with the defendant in the first place. And if that interaction was improper, it dismisses the case. That's the whole part of having a motion to suppress. It excludes the illegal fruits of the evidence that is obtained after the fact. But again, I have not reviewed those opinions, so I cannot tell the court one way or the other what my position would be based on those opinions. But I do believe that given the circumstances of this case, we should be allowed to go forward with our motions.
Mr. Mayor, I'm not sure, but your sound is kind of cutting out.
Oh, I'm sorry.
So,
I'll try to speak up louder.
Thank you.
Thank you.
Your Honor, if I may,
Yes, ma'am.
to prove a evading arrest, you have to prove that it was attempted lawfully. And in Davie State, it says the exclusionary rule, which is the motion to suppress, was not designed to protect individuals from the use of trial of evidence that was obtained in an unlawful manner.
Excuse me, can you slow down, please?
Yes.
Protect individuals
From the use at trial of evidence that was obtained in an unlawful manner. Further, in Utah v. Strife, which is a United States Supreme Court, it states an arrest pursuant to a valid warrant is a ministerial act that is independently compelled, regardless of whether this initial detention was unlawful. This is asking us to prove an element of the case, which is better suited, again, for trial, and that would be when the defense could ask for a directed verdict, not in a motion to suppress.
All right. What is the site for Utah?
It is 136 Supreme Court 2056.
All right. I want to hear at least sufficient testimony to clarify for me whether this in fact lies within Woods or Day or Utah. So this is your case at this point, Mr. Vale. Go ahead and proceed.
Yes, Your Honor, I would call Officer Cooper. I think he's on.
Officer Dustin Cooper.
Yes, sir.
All right. Would you raise your right hand?
Yes, sir.
You solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth.
I do, Your Honor.
Thank you, sir. You may put your hand down. Mr. Vale, your witness.
Thank you, Your
Your
Honor.
Honor.
Yes, ma'am.
I was just reminded, can I go ahead and mute you? And I'll go over there. I was just reminded of something you have this afternoon.
All right, ma'am, yes.
I'll be
We'll
right
take
there,
a-
Judge.
We'll take a real brief. All right, the court's going to take about a 5-minute recess. I need to attend to a matter.
Okay, Judge.